Good afternoon, everyone. My name is Sandra Taylor. I'm the Executive Director of the Georgetown Hospital Foundation. The three foundations of Halton Healthcare, which compose Oakville Hospital Foundation, the Milton District Hospital Foundation, and Georgetown Hospital Foundation, have teamed up to offer these information sessions on estate planning. I am very thrilled to welcome you to today's session, Where There's a Will, Top 10 Tax and Legal Tips. I will be your moderator for this afternoon's session, but first, we just have a few housekeeping items. We are recording this presentation and we'll send you the link in the next couple of days, along with a copy of the presentation that you'll see on the screen. You are all muted, so if you have a question or comment, please use the Q&A feature at the bottom right of your screen, and we will answer your questions at the end of our presentation. Before I begin, I'd like to provide you with a quick update on what's been happening at Georgetown Hospital and across Halton Healthcare in the last few months. First, I want to thank and acknowledge the many donors who have stepped up right across Halton to help the hospital purchase much needed equipment, such as ventilators, beds, and PPE. There's also been an outpouring of messages, meals, flowers, and other items for our frontline workers. We are so grateful for the tremendous support our community has shown, and I know that all of our workers appreciate all the love that they've received and send it right back to all of you. As you may have noticed, we've begun ramping up again at the hospital, allowing some visitors once again, reopening our clinics, and increasing our surgeries. We still have COVID testing centers at each hospital site. These are by appointment only. And to book an appointment, please go to the Halton Healthcare website at haltonhealthcare.on.ca. I'll say that again, haltonhealthcare.on.ca for the number to call to book an appointment, or you can also book online through the website. For today's session, I'd like to introduce Alexandra Manthorpe and Mark Haneen, our two esteemed panelists today. First up is Alexandra. She's a lawyer at O'Connor McLeod Hanna LLP in Oakville. Alexandra's focus is estate and trust planning, business succession planning, and estate and trust administration. She enjoys helping prepare clients for the future in order to protect themselves and their loved ones in the best manner possible. She also enjoys guiding clients through the process of being an estate trustee or executor. Alexandra is a member of the Canadian Bar Association, Ontario Bar Association, the Halton County Law Association, and the Estate Planners Council of Halton. I also want to say congratulations to Alexandra and her husband as they welcomed a new baby boy this summer named Jeremy, and I'm sure his twin big sisters are very excited by his arrival. Our other panelist today is Mark Haneen, who is a Senior Wealth Advisor and Director at Scotia Wealth Management, and has been working with entrepreneurs and professionals since 2001. His expertise includes the management of significant liquidity events for clients. Mark also manages portfolios focused on capital preservation and tax-efficient income generation. Mark is a contributor to the Globe and Mail, writing about investment and financial planning, and has several professional financial designations. Mark and his family live here in Georgetown, and they're quite active in the community. And I'm proud to say that Mark is the past chair of the Georgetown Hospital Foundation. So we'll get started right away. Right now, I'd like to turn things over to Alexandra to get us started.
Thank you very much, Sandra. I'd just like to welcome everyone today. I'm delighted to be presenting to the Georgetown Hospital Foundation and everyone at the Halton Healthcare Group. It's an important time to think about charities. I sit on the board of a charity, and I know it's a rough time. So it's great that you're here today. You're thinking about estate planning, maybe possibly including a charitable gift. And I hope you learn some things today that will guide you in your own estate planning. So what we're going to do, I'm going to start, I'm going to speak about powers of attorney a little bit, then move into wills and move into trusts, and then I'll turn it over to Mark to talk about beneficiary designations, co-ownership of assets, and a few other things, including some tax planning. What we'll do, if we could just get the first slide up, I'm going to start with powers of attorney. So I know a lot of you are probably tuning in today and want to hear me talk about wills, and I will get to wills, but often overlooked critical part of estate planning are powers of attorney. So what are powers of attorney? A power of attorney is a written document in which you appoint another person or person to make decisions on your behalf during your lifetime. So the person giving the power of attorney, we call them the grantor, the giver, and the person acting under the power of attorney document is the attorney. There is a bit of a misconception sometimes that your attorney, the person you name to make decisions for you, needs to be a lawyer. That's not true. When I speak of attorney under power of attorney, I'm simply referring to the person or persons, or perhaps even trust company, who you've named to make decisions on your behalf. In Ontario, we have two types of powers of attorney. Power of attorney for personal care, who makes medical decisions for you if you cannot make medical decisions for yourself. And I should say, it's not just medical decisions. It's where you live, what you eat. Do you say yes to surgery? Do you say no to surgery? So really anything affecting the body. And the other type is the power of attorney for property. Powers of attorney are critical in case you suffer a medical emergency such as a stroke and you lose mental capacity. So if you're unable to give instructions to the bank, to the doctor, to someone like Mark about what to do with your assets, it is critical to have powers of attorney in place before you become incapable, because this allows another person to make decisions on your behalf. So what happens if you don't have powers of attorney? If you become mentally incapable and you do not have power of attorney documents in place, and a person, usually a spouse or a family member, may need to apply for what's called guardianship. Just like with the powers of attorney, there's a guardian for the person, so who makes medical decisions for you, and guardian for property, so who makes property decisions for you. There is a list of people who can make a limited range of power of attorney for personal care decisions. If you don't have the power of attorney for personal care in place, it's family members. So it goes spouse, kids, further and further out. But very importantly, and if you take one thing away from what I'm saying about powers of attorney today, please take this away. No one, not even a spouse, has an automatic right to make property decisions for you if you do not have a power of attorney for property. So it is very important. If you become mentally incapable and you do not have a power of attorney for property in place, then your spouse, your child, your brother may need to apply to court to become your guardian. Guardianship can cost tens of thousands of dollars. It can be a very expensive process. And the person who applies may not be the person you would have wanted. It could be your reckless brother, who you didn't want managing your money. It could be your child who you don't have total confidence in making decisions for you. So please remember, when you are doing estate planning, don't overlook the importance of powers of attorney. So I'll move on to the next slide, talk about wills next. So most people know what a will is. So what's a will? A will is, again, a written document you make while you're alive, and it basically says what should happen after you die. For the most part, it deals with property, what should happen with your property. But as you'll see, I have a note at the bottom of this slide. If you are a parent, you do need to think about things like a guardian, again, same term, but different situation, basically a custodian for your child. So if you do have a minor child, a will should address who you want to be custodian for your minor child. And a minor child is a child under 18 in Ontario. I say this every presentation I do. So if you've heard me before, you've heard me tell this story before, but it's a good one. I was speaking once and I had a gentleman actually come up to me and say, Alexandra, if I make a will, I'm going to die. And I looked at him, I said, you're going to die, make a will. You are not magically preventing your death by not making a will. There is absolutely no bad luck with making a will. In fact, you will feel better when it's done. And I can tell you, it is cheaper, it is better, it is just such a relief for your family. A well-written will prevents so many problems later on. Not having a will is the problem. And again, thinking, oh, if I do this, it's bad luck. You got to get that out of your head. It's an uncomfortable thing to think about. No one wants to think about dying. Having a will really, it actually saves money, saves problems later on. And it is something you'll need to update during your lifetime. One thing I always point out to people, and I should note there's a proposal to change this, but really whenever a significant relationship begins or ends, you get married, you start to have a common law relationship with someone, you move in with someone, or on the other side, you separate, you divorce, your spouse dies, you should update your will. In Ontario, currently legal marriage, not a common law marriage, that's a critical distinction. Legal marriage automatically revokes a will. This does not apply in certain other provinces like BC and Alberta, they've gotten rid of this. But in Ontario, it still applies, although I should note there are currently proposals to maybe get rid of this. But it again makes you realize any new relationship, beginning or ending, you got to update your will. Conversely, separation or divorce does not revoke a will. So if you did a will with your spouse and you've since divorced that spouse or separated from that spouse, it's very important you update your wills and your powers of attorney to remove that person and to put in what you want to put in. We talked about kids a little bit. It's critical to include trusts in your will for minor beneficiaries. So whether it's a child, it's a grandchild, it's a niece or a nephew, or even friends or children of friends, kids under 18 do not have full legal rights and can't receive property directly. So you need to include a trust so that they receive it at a later age. And the neat thing about trusts, I include trusts in almost all my wills, is that you can put an even later age. So if you don't like 18, and frankly, I don't trust most 18-year-olds with money. I was an 18-year-old once, and I know I wasn't particularly wise with money at 18. You can include a later age. Do I want my kids to get their money at 25? Do I want my kids to get their money at 30? Do I want to stagger it so they get a little bit at 25, a little bit at 30? This is something you should be thinking about before you meet with your lawyer, because it's going to be a question. Okay, you know, you want to give everything to each other, and then if you're both gone, you want to give it to the kids. Well, what age? 25, 30, include a trust. Very important things you can also include in wills is specific legacies or gifts. So let's say you want to give, you know, the cottage or the family home to a particular person, or a specific cash amount, say $25,000 to the Georgetown Hospital Foundation, $100,000 to sick kids, whatever. If you want to include a specific gift, whether it's a tangible item like a cottage or a house, or a piano, or if you want to include a cash gift, you got to put that in the will. It's also very important to include trusts, which I previously mentioned, for minor beneficiaries, for disabled beneficiaries. So if you do have any disabled beneficiaries, or I should say, because people think, oh, he's not disabled, anyone on ODSP, Ontario Disability Support Plan, there should be special trust for those beneficiaries in your will. The other key aspect of a will is an executor. An executor, an estate trustee, or an executor, same thing, just a new word, estate trustee. An estate trustee executor is the person who administers your estate. So this will be the person who arranges for your funeral if it's not pre-planned. They will distribute your personal effects in accordance with the terms of your will, and they will distribute everything else in accordance with the terms of your will. So it is very important to appoint the right person or persons, or even trust company, as your executor. A trust company, I mentioned that name before. If you're not familiar with what a trust company is, trust company is basically a professional executor, a professional attorney for property. There is a trust company affiliated with each of the major banks. So for example, if you're with Mark, you're with Scotia, you might want to go with Scotia Trust. But all of the major banks have an affiliated trust company. And they're a great option if you don't have anyone appropriate in your family. So if you don't have any close friends, family members, or let's say if you're an immigrant and your family resides outside of Canada, a trust company could be a great option to discuss with your lawyer about who you should be as your executor. Next slide, we'll just talk about intestacy. So intestacy is when you die without a will. Avoid it, avoid it. Some people think, oh, Alexandra, I don't want to spend the money on a will. My family will just sort it out. Intestacy is very, very rigid. The rules of intestacy are basically 300 years old, and we haven't really changed them since then. Currently, they exclude common law spouses. So if you're thinking, oh, when I die, it'll just all go to my common law spouse, I don't need a will. No, common law spouses are excluded under intestacy at present. What about a stepchild? Stepkids are out. It's only biological children. So common law spouses, friends, charities. Again, you're thinking about a small gift to Georgetown Hospital Foundation. Under intestacy, it's not going to happen. There's literally a chart about who gets what, and it's based on relationships. The other critical thing with not having a will is you do not have an executor. Because the will document, generally a well-written will, appoints an executor. So if you don't have a will, you don't have an executor, which means no one, again, has an automatic right to list your home, try to sell it, deal with your bank accounts, even paying for your funeral. And there can be fights about this. So again, if your kids don't get along, there can be a fight over who gets to be your executor. Intestacy, put bluntly, it's not desirable. And I've actually seen intestate estates can cost more to administer than by having a good will. If you have a good will, you pay a couple $1,000 in advance, it can save you thousands of dollars, tens of thousands of dollars after you pass away, especially if you fail to provide for someone who is dependent on you, like a common law spouse. So definitely avoid intestacy. Like I said, I know it's not fun to think about death, but just do it, because leaving a mess for your family is really to be avoided. We'll move on to the next slide, and I'll just briefly speak about multiple wills. So you may have heard about these. So when you die in Ontario and you have certain assets, your executors need to pay estate administration tax. It was formerly called probate tax. It's now called estate administration tax. They need to pay that on certain assets. So generally, if someone dies and they're the sole owner of bank accounts, of a home, non-registered investments, generally their executor will have to pay probate tax on those assets in order to receive probate from the court, which is proof of the will, proof that the will's valid. They need that before they can sell or access those assets. But very, very critically is you don't need to pay probate tax on all assets. So if you have a private Ontario business corporation, let's say you're a dentist and you've got a private professional corporation, or you're a doctor, a private professional corporation, or you're incorporated, you've got a family business with your brother, with your child, with your spouse, your executors do not currently require probate, proof of the will, to deal with the shares in the company. So a very common planning technique for my clients who have private corporations is to do two wills. So essentially what they're doing conceptually is they're creating a will for their assets that require probate. Like I said, bank accounts, non-registered investments, usually their home. And then they're creating a second will that avoids probate. And so they're putting their shares in their private companies in there. You can also put artwork under there. You don't generally need probate for artwork. You know, if you got a group of 7 painting, they might want kind of proof that it's yours, but generally artwork, and very importantly, is household effects. So this is really critical, because it means your executor may not have to get an appraisal of everything in your home when you die if you've got significant furniture, artwork, that sort of things in your home. So just keep that in mind, that if you do have a private company or assets that don't require probate, you should discuss with your lawyer, hey, you know, someone told me about multiple wills. Does that make sense in my situation? Is that something I should be creating in order to reduce estate administration tax? I'm also going to talk about trust a little bit. So most of you have heard about trust. The most common trust, we'll just move on to the next slide. Yeah, so the most common trust is actually the one mentioned at the bottom there, is family trust. So this is a very common planning technique. Again, for business owners, is where they have a family trust, they've got a private company, and often they're using the family trust for income splitting purposes. There were, I just need to emphasize, there were some very important changes to the Income Tax Act in 2016. So it's important to review, if you have had a family trust, you've had it for 5 or more years, definitely review with your accountant if a family trust still makes sense. Because the planning, there was a bit of a pretty significant change in 2016. The family trust can still be a very appropriate way to, do some tax splitting while you're alive. And also an important thing conceptually is when you put an asset in a trust, you don't own it anymore, which means it's not yours when you die, which means it's not subject to probate tax. So a trust can be a neat vehicle for planning while you're alive. One thing I want to mention, it's not well known. They've been around for, I think, about 20, 25 years, maybe longer, is something called an alter ego trust if you're a single person, or a joint spousal trust, sometimes called a joint partner trust. They are a very unique, what we call a self-benefit trust. It's a self-benefit trust is set up while you're alive. Basically, you got to be 65, or I should say the creator has to be 65. So if you're 65 and you want to set up a trust for yourself while you're alive, you can do an alter ego trust. If you're 65 and you want to set up a trust for yourself and your spouse, and that can include common law spouse, so it's legally married spouse, common law spouse, you can create a joint spousal trust. What it is basically you are the beneficiary of this trust while you're alive. And when you die, you name beneficiaries right in the trust deed, and the assets remaining in the trust after you die go to those named beneficiaries. So it is in some ways a will substitute. It's a great planning technique. Again, it's particularly helpful in reducing probate tax. One of the assets, for example, that you can put inside an alter ego trust is a home. You could put your home in there. You could put the family cottage in there. There are some income tax consequences. So it's very critical to, again, discuss this with your financial advisor and with your accountant before creating it. But an alter ego trust or a joint spousal trust can be a great planning technique. Probate tax, estate administration tax planning technique when you're 65 plus. The one thing I just want to mention is you cannot put everything into an alter ego trust. So certain registered assets, like if you've got an RRSP or a RIF or a TFSA, those cannot be rolled into an alter ego trust or a joint spousal trust. So it's very important to still have a will, because in case something isn't rolled into your trust, you still have to have a will to address those other assets. So I'm going to turn it over to Mark. I think Mark's going to move on to beneficiary designations, was our next slide. And I'll stick around at the end for questions. So if I've said anything that you have questions about, certainly please use the Q&A feature, because I'll stick around at the end and hopefully can address your question. I'll go on to Mark.
Thanks, Alexandra. So that was some great content, and hope you all got some good nuggets. As I'm about to start speaking, generally speaking, we're doing this in person, and I would say put your hand up if you feel you pay too much tax. And invariably, everybody puts their hand up. And so we're going to talk now about a few ways of paying a little bit less tax, both once you're living and after you've passed. So the first one is looking at your beneficiary designations on all of your accounts, whether that's a bank account, an RSP, a RIF, tax-free savings account, trust account, anything that has your name on it. We want to look at who the beneficiary is. RSPs and RIFs, if you have a spouse, you can appoint your spouse as the beneficiary, and on your passing, the money rolls between each other, tax-free, without any penalties or taxes at all. And it's a fairly efficient process. Tax-free savings accounts, TFSAs, are a bit different. They were created back in 2010 and will likely replace the value of an RSP over the next 20 to 30 years for those that are regular savers. So they'll become significant parts of people's overall net worth as time goes on. So it's important to understand the differences between tax-free savings account beneficiaries. So if you have a spouse or a common law partner, you want to name them as your successor holder of your TFSA. What a successor holder means is that your TFSA rolls into their TFSA just like an RSP or a RIF would, without any tax implications upon your passing. Otherwise, if you do not have a spouse or common law partner, or you do not explicitly ask your financial advisor to name your spouse as the successor holder, they will be named as a beneficiary on the tax-free savings account, or perhaps even in the will. And if that happens, a tax slip is issued on the passing of the person that owns the TFSA, and it can then be taxable to that estate. And so we want to make sure that all the gains after the passing of that individual are not taxed. And so the best way to avoid this is to make sure that you are a successor holder on your spouse or common law partner's tax-free savings account. So that's a key takeaway I would hope you all take with you, to go ask your advisors to make sure that you are the successor holder for the other folks in your life. So the And I should also point out on the last line there that non-registered accounts, there's no ability to name in or regular day-to-day bank accounts any type of beneficiary. So that would all flow through to the will. So to Alexandra's point earlier, please make sure that your will is updated regularly and it meets your current wishes. So on the next slide, we're going to talk about the co-ownership of assets. And this can be a bit of a lightning rod type of conversation with folks, as they may want to have a joint account with their child, or on the other side, they may have a joint account with their parents. So it's usually recommended for spouses. Joint accounts are a good idea, but otherwise, in any of those other two scenarios I painted, there can be risks. We always want to try to understand why they're making these assets joint. What is the ultimate goal? So if the purpose and the true intention is what we are trying to drill down to, we're trying to figure out who controls the funds, who can access the funds, who pays the tax, and ultimately, who's the beneficiary and what's the situation of that new joint owner. So if they are someone who's going to spend all the money, we want to be careful that they don't have that ability to just withdraw the capital and go out and buy that Ferrari while mom still needs that payment for her long-term care home. So there's two common misunderstandings that I would like to highlight with regards to joint ownership of assets. So number one, if a child is making a joint account with a parent, and as the parent their health is deteriorating or they're even incapable, this could result in unintended tax consequences or potentially exposure to the joint holder's creditors or a loss of control. So if you own a business and you hit financial troubles and you have a joint account with mom, all of a sudden the creditors may be able to go after mom's assets. So a legal power of attorney can accomplish the same task as a joint account. That first slide that Alexandra brought up about power of attorneys is very, very important, and perhaps a much more valuable tool than having a joint account with mom or dad. Another thing that we hear often is if a friend, which often means them, told me that if I add children to my account, my estate won't have to pay probate because my kids will live long past me. So while this may be true that you may bypass probate because there are other owners on that asset, it may not be true if there's other intricacies, if the will shows other beneficiaries in that account. And it could create a complex situation that Alexandra will need to roll her sleeves up and come in and solve for you. So be very careful, but when you're just trying to bypass probate, you may be opening a whole other can of worms. So on the next slide, we'll hit a very fun topic that we love to talk about is donating money to charities. The most efficient way to donate money to charity is by donating stock. If you have a non-registered account or even a corporate account, personal or corporate account with unrealized capital gains, so if you bought a stock, you've held it for a number of years, you've now made good money on it, and you don't want to pay that tax. However, your local favorite charity is someone you want to be helping out. An idea that you could help them with is by donating that stock directly to the charity. There's a significant benefit of you doing this versus you writing them a check. It is always more beneficial for you to donate stock versus donating cash. I put a table here in the presentation, which you'll all receive a copy of later, but I'll briefly walk you through this chart. So if we have $100,000 stock or mutual fund or bond or any other publicly traded security, we paid $50,000 for it. So we would end up having to pay $11,250 of tax if we were to sell that security. If we choose to donate that to a charity, that $100,000 goes directly to the charity. That's right, the full $100,000. You will end up saving $33,750 if you donate money, cash, directly to a charity. Not cash, but donate securities directly to the charity. You are much further ahead when you donate a stock certificate from your investment advisor to that charity. Every charity will be able to provide you with a form that will go directly to your advisor, where they'll be demonstrated exactly how to send those stocks to that charity. And I assure you, charities very much appreciate it, as the data shows us that we're all more generous when we donate stock versus cash. So I'm going to close there, and then let's see if we have some questions here. And perhaps, Alexandra, I'll hand it back to you to talk about when to update wills and powers of attorney.
Thank you, Mark. Yeah. So I'm basically, when to update is whenever your life changes. I mean, it's very critical for everyone to have a will, everyone to have powers of attorney, but obviously the will and the powers of attorney you make when you're in your 20s and single are very different from the ones you should have when you get married. Maybe you're in your 40s, you're earning good money, your career's at its peak, and you've got young children, versus when you're maybe 70, 80, 90, and maybe your spouse has passed away. You've got children, they're grown up, you've got grandchildren, maybe you want to support, set up some educational trust for grandchildren. So you should be updating it. I would say it's not uncommon for people to have 3 or 4 different wills in their lifetime. And the flow of things can be the same, to my spouse, to the kids, but the situation will change. If someone becomes disabled, you should be setting up a special trust for them so that it doesn't potentially imperil their entitlements under Ontario Disability Support Plan. If someone is just young, you might want to set up a trust for them till they're 25 or 30. Another important thing people forget is if your kids move to different countries. So for example, if your son moves to the US or your daughter moves to England, you should be updating these and possibly speaking with lawyers or accountants in those other jurisdictions about the tax implications. The US in particular is a very, it's a strange beast. It's a strange beast in every regard right now. But when it comes to taxation, it is very, very different from Canada. And there can be tax implications for the beneficiary if they're living in the US. So really, whenever your situation changes, someone is born, someone dies, your assets change, you should be speaking with Mark, you should be speaking with me, you should be speaking with your accountant to update your will, your powers of attorney, checking your beneficiary designations, and also checking how you own your assets. Does it make sense to add your child to the bank account? What are the tax implications of doing that? And as Mark said, and I'm so glad he emphasized that, it's not always clear cut. I know people want to avoid probate and probate tax, but you don't want to create a whole other can of worms, open a whole other can of worms, simply trying to avoid probate. It's all part of kind of the overall estate plan. So I'll turn it over to Sandra. I think Sandra's going to read our questions, and it looks like we did receive 1 or 2.
Great, thanks, Alexandra. I know that for everybody, updating or even making your will for the first time and establishing those powers of attorney can be a daunting task. And we thank you for clarifying some of the key issues we need to consider. There's obviously a lot of information that you've given, so we do have a few questions coming up on that. I think it's also easy to overlook some of the tax implications of the gifts we want to give our family and to our charities. So thank you, Mark, for giving us food for thought on items we want to discuss with our financial advisors before we go to somebody like Alexandra to make our will. And at this time, I'll go through questions from the audience and ask each of you to answer the appropriate ones. If anybody wants to ask a question, please use the Q&A feature at the bottom of the screen. So the first one I have, I think this is for Mark. If I give my RSP to charity, is it taxed differently than if I give it to a child?
So if you aren't leaving your RSP to a spouse or common law partner, the day that you pass away, it's considered as if it was all withdrawn and disposed of. So the day you pass away, let's say you have $100,000 in a RIF the day you pass away. The day you pass away, that $100,000 is considered taxable T4 income, taxed as income as if you went out to work. The residue amount from there, let's say you're at a 50% tax bracket and say there's $50,000 left after tax. You could choose then to donate that remaining balance to a charity or family member, give it to a family member, however you see fit. And unfortunately, it's not a very tax efficient solution. Donating money out of a RIF or without a spouse or common law partner, you're going to have to pay the CRA before you get to do anything first.
Great, thank you. Okay, we have a couple more here. I think this one's for Alexandra. My son is in a common law relationship and does not have a will. If he dies, will his common law automatically inherit his estate?
Currently, no. No, and that's critical. There is still a big difference between common law spouse and legally married spouse in intestacy. Now, like I said, the rules of intestacy, they're about 300 years old. People think I'm joking. No, they really haven't changed in about 200 or 300 years. They exclude stepchildren. They exclude common law spouses. They exclude friends, charities, other people you maybe would have wanted to benefit from your estate. Let's say you're estranged from one of your children and you want to cut them out. If you die without a will and they're one of your kids and they're, they could be getting a share of your estate. So currently, no, common law spouses do not get the entire estate. If someone dies without a will, it goes, the first beneficiary is their legally married spouse. If they don't have a spouse or they have children, it's usually a combination maybe of the legally married spouse and the children. Don't have any children, then it goes up to parents, and then it goes out to brothers and sisters and further and further. So if your son doesn't have any children, you might be the beneficiary of his estate if you were to die without a will. Now, that doesn't mean his common law partner can't sue. And in fact, I would say it's highly likely she will sue. It's called a dependence relief claim. So quite often we get very sad situations. Someone has died suddenly, unexpectedly, they were young, they did not have a will. The common law partner of 5 years, 10 years, 50 years is excluded because of these old rules, and they're having to sue the estate of their loved one to get their entitlement. This is not a situation anyone wants. I don't like these situations. No one likes these situations. They're sad, and they can be prevented by having a will. So if you have a will, you can include a common law partner very easily. So your son absolutely should make a will to benefit his common law partner if that's what he wants to do.
Great, thanks, Alexandra. I think the next one's for you as well. Can you just do a brief overview of what exactly probate is and how long does it usually take? So
probate, so I'm going to call it probate. For some reason, the brilliant people in the Ontario government decided that probate was too difficult a word. So the new term is certificate of appointment of estate trustee with a will. So that's a lot longer. So I'm just going to call it probate because everyone knows what probate is. Probate is where you take the will. So this is my Alexandra's last will. I've died. So my executor I've named in my will takes my original last will to court and basically asks the court to confirm that, yes, this is indeed Alexandra's last will. It's valid, it's effective. The court stamps it. You pay probate tax to get the court to stamp it. But once the court stamps the will and issues probate, then your executor has authority, court authority, to deal with all of your assets. So once an executor has probate, Mark can't hold back the funds anymore. He's got to give it to the executor. The executor can list and sell the home. That's very important. So without probate, generally your executor cannot legally sell your home. So probate is basically court confirmation of the will. If you die without a will, your executor similarly has to go to court. It's not called probate, it's called certificate of appointment of estate trustee without a will, but it's a similar process. How long it takes depends on where you live. So your executor, you can't pick your court, unfortunately. So your executor or the person wanting to be your executor, if you don't have a will, needs to apply to the court where you were living when you died. So I live in Toronto. So if I were to pass away, my executor would have to go to the court in Toronto. If you live in Georgetown, Milton, Oakville, it's the Halton Court. If you're in Mississauga, it's the Peel Court. And all of these courts have different times. Halton historically has been one of the better ones, but right now, and I have to say with COVID, it's a nightmare. Everything is slammed to a complete halt. But I would say in normal times, Halton was taking 4 to 6 weeks to issue probate. So that means you apply and you're waiting 4 to 6 weeks to access the deceased person's assets. Peel was more like 2 to 3 months. And Toronto, boy, like it's like throwing it down into a black hole, maybe 6 months. Which means that if mom dies in Toronto, it could be 6 months before you can sell her home. So again, do you have the funds for carrying costs and everything else? So probate, it can be an issue. It's worth planning for. It's worth discussing with your lawyer. Are there ways to avoid probate? But the process really varies. And I just have to say, since COVID, you may have heard the courts shut down. Temporarily, they're now operating kind of on a partial basis. But if it took, a month before COVID, it's now taking 2 months or so. So things have slowed down since COVID in terms of getting probate. So it's worth discussing with your lawyer. Are there ways to avoid probate that don't cause a massive tax problem for me somewhere else?
Great, that's an excellent answer. And I've got another question that kind of is along the COVID line. Given everything that's going on, I'm scared to meet with my lawyer, especially since I have underlying health issues. So what can I do, or how can I sign my will and power of attorney?
Great question. And it's something that comes up every day. I, like you, like everyone here, I started working remotely in March. I was pregnant at the time with my son, Jeremy, and I just couldn't risk meeting with people. And my clients didn't want to see me. Everyone was scared. Everyone's still scared. So it's a real issue. One of the things the Ontario government did quite quickly was that they allowed for the remote signing of wills and powers of attorney. And this was revolutionary. And people think, oh, you're joking, right? Like, couldn't I always do that? Wills and estates is old. I was telling you the rules of intestacy, they're 300 years old. The signature or execution requirements for wills and powers of attorney were also 200 to 300 years old. We had to physically be in the presence of the testator, who's the person who makes the will, testator or testatrix. So I would have to go to meetings with my assistant. I would have to watch the testator sign. Then I would sign as the first witness. My assistant would sign as the second witness. We'd all have to sit together in the same room, watch each other sign physically, everything, everything in person, which meant if a client was ill, I was running up to Oakville Hospital, Georgetown Hospital to witness wills and powers of attorney for people. They changed this during COVID so that we can meet with people remotely. Now, what was allowed was, for example, a Zoom. We're logged on to Zoom today. So if 2 neutral witnesses watch the testator sign, so if I watch you sign, then we can sign later, and that is a valid and enforceable will. I need to emphasize, this was part of the emergency order. So, but they're right now they're working on making this a permanent change to the Succession Law Reform Act and the Substitute Decisions Act. So it looks like very soon going forward, you will be able to execute your will and powers of attorney remotely. But of course, and our issue, and we're aware of this, I'm involved with elder law, is older people might not have the technology. So, I mean, if you don't have a computer or a laptop, or you're not sure about Zoom or any of these platforms, this may not be an option for you, because there's both a visual requirement. I have to see the person sign, and we have to be able to communicate with each other. Both audio and video technology is required. But I just want to say there are solutions. So if you're putting off doing your will and your powers of attorney because you're scared to go into your lawyer's office, don't be. Call your lawyer. We've all had to adapt to this. And most of us are meeting with clients through Zoom or maybe we're having the initial meeting by phone. Otherwise, I would say my office and many other offices, if we do have to meet with someone in person, we have set up PPE, protective equipment. So talk to your lawyer, because there are currently some solutions. If you're scared to meet with your lawyer, we might be able to get your will and power of attorney done without having to physically be in the same room. Or we might be able to come up with a solution where we stay apart from each other, different ends of the same room or something like that. But very much a valid concern.
Great, that's fantastic. Alexandra, I got another one for you. We'll just keep you on. My son lives in the US and I want him to be the executor. Is that a problem?
Yes, it's a problem. Your son, and I need to emphasize, because people will say, but he's a Canadian citizen. He might be a Canadian citizen. Citizen is just an immigration thing. He is likely a non-resident of Canada for income tax purposes, and that's the problem. So if your executor, who is the administrator of your estate, lives outside of Canada, the CRA may take the position that care and control and management of your estate is outside of Canada. It's a non-resident estate. You can have the income tax problems. So you do not want generally someone who lives outside of Canada on a permanent basis to be your executor, to be your attorney for property. There's also just logistical issues, especially now in the pandemic. If you name someone who lives in Florida, are they going to be able to come up here and administer your estate when you die? If your son lives in Florida and you have a stroke, are they going to be able to come up here quickly and administer your assets while you're alive? So again, before the pandemic, we could all hop on planes. Hopping on a plane now is very difficult, and international borders are closed. So I would say the things to watch out for, there could be tax implications. If you name someone who lives outside of Canada, there can be logistical problems. They may not actually be able to come to Oakville, to come to Georgetown, to administer your estate, to do those things that need to be done in person. And just practicality more than anything. Is it practical to have someone who lives so far away do these things? So if you do have a family member who is a non-resident of Canada, even if they're a Canadian citizen, if you have a family member who lives in the US, who lives in Australia, who lives in England, tell your lawyer, please, because that person, it may not be appropriate to name them as an executor or as your attorney for property. There can be tax implications. And Mark knows that too. I should just, I'm sure he's aware of that as well, that some financial advisors in Canada are actually not permitted to take securities instructions from someone who's not a Canadian resident. So there can be some implications. They, Mark would say, you're in the US, I can't listen to you, I can't take instructions from you. So please, again, talk to a lawyer, talk to an accountant, talk to your financial advisor, because an American in the family can make things a little bit more complicated.
Great. Mark, do you want to jump in on that? Anything to add to that question?
I would add that jurisdictions are actually provincially based, Alexandra. So
Yeah,
it could even
true.
be the child lives in Quebec, parents live in Ontario. If I'm not licensed in Quebec, I can't actually deal with the kids.
Mm-hmm.
So you need to inquire to where you're licensed and where your advisor's licensed to know that they could deal with the beneficiaries.
Yeah, critical. And there's sometimes rules, like let's say that your only son lives in the US. So you have no other family. You want to name your son as the beneficiary. You want to name him as the executor. There's no problem with making your son in the US the sole beneficiary. But if he wants to be executor, again, I've talked about there's some tax implications. The court may not permit him. He may have to pay a bond or security because he lives outside of Canada. Another thing I'll just mention too is if you die without a will, anyone who lives outside of Ontario is not even permitted to apply to become your executor. So these things are also provincial. And related to that is, let's say you've just moved to Georgetown, you've just moved to Oakville, coming from BC, coming from Quebec. If you have a Quebec will and powers of attorney, if you have a BC powers of attorney, you should probably update them, because wills and powers of attorney are also regulated provincially, and there are some differences in nomenclature and differences between the provinces. So yeah, anything between the provinces in a different country, mention it to your financial advisor, mention it to Mark, mention it to me, mention it to your accountant, because there may be things you're not even aware of that can cause problems later on when we really need these people to be able to act.
Great, another one. And here's another great question, kind of a bit of the reverse, because many people here are snowbirds and may own property in the state. So what are some of the considerations with that in terms of you may die unexpectedly and not be able to liquidate that before you pass? How should you deal with any property you own outside of Ontario in your state?
I actually work quite frequently with U.S. counsel. So it's not uncommon, for example, if someone does have a home in Florida, I'm using Florida because that's probably the most common for Ontario. Someone has a home in Florida, they have a home in Ontario, assets in Ontario, they may need to do a U.S. will for their U.S. assets, and they may need to do a Canadian will, an Ontario will for their assets up here. So that again goes to that multiple wills. You may need a will for each jurisdiction where you have assets. Another very popular planning technique for people with assets in Florida is a so-called residence trust. So you might actually want to set up a trust while you're alive, where the home is held in trust maybe for you and your spouse while you're alive, but then when you die, it goes to the kids. So one of the benefits of a well-drafted residence trust is it may be able to avoid probate when you die. Otherwise, I've had situations, so if a person just has one will, so same situation, they've got a home in Florida, they've got a home in Ontario, they just have one will. I've had situations where the kids are having to get probate in Ontario, and then they have to also get probate down in Florida. So as I just said to you, it can take a couple of months to get probate up here, and then they're taking probate and they're going down to Florida, which can take another couple of months. Something called ancillary administration down there in Florida. All we're talking about is delay after delay after delay after delay. So there's some situations where a person, without realizing it, it can sometimes be a year before their executor is legally in a position to be able to liquidate their home in Florida, which can be a problem because we've seen Florida home prices go up and down. Is there a hurricane coming? What's the currency rate? You know, this, that, the other. So if you do have assets in another jurisdiction, please mention that to your Canadian lawyer, because your Canadian lawyer might need to consult with a US lawyer about what is the best planning for you. And just a final aside is if you are a higher net worth individual, you need to watch out for US estate taxes. The US is very mean that way, that even if most of your worldwide net worth is in Canada, if you're rich enough, the U.S. is going to try and tax your estate. So something to watch out for.
Great, another excellent answer. So I think we have one more question here. I'm going to start with Mark, and then Alexandra, if you have anything to add. But Mark, if somebody's having trouble deciding which may have a bunch of different financial instruments that they've been using, whether it's stocks, as you mentioned, TFSAs, RIFs, those types of things. How do you determine sort of which goes to each child if you have multiple children, or is it better for it to just go to the estate in general and then split it up from there? What are some of the considerations that go into that?
It's a great question. So we generally start by preparing a financial plan to first figure out the short, medium, and long-term objectives for the client, where their income needs to come from. We generally want to mitigate tax both before and after death. So usually that means withdrawing drawing your income from all of the above, everything you just said there, Sandra. So looking to pull some money out of registered accounts, some money out of non-registered accounts, in the spirit of getting money out of the right place in the most tax efficient way. So there's not really a one size fits all answer. I'm not trying to be vague, but it really does matter to the individual, to their individual situation, if they have a spouse, and what their income needs are. So tough question to answer, but I'm pleased to take that offline and to get into more detail with that individual's specific situation if they would like. And I believe our contact information is at the end of the presentation.
Great. Okay. So we are just about to wrap up for today. This was a great session, lots of information. I do remind you that we will be sending you both the recorded copy of the presentation today, as well as the slides you saw on the screen, so that I know there was a lot of information that was shared. I want to thank Alexandra and Mark. We're so appreciative of you taking the time and sharing your expertise with you. You obviously have a wealth of knowledge. I think we could have done this for about another hour or two. We also will be sending all of the participants that are on the call today a quick survey in the next day or two. We would appreciate your comments as we look forward to doing more of these sessions in the future. And we thank you once again for joining us. In terms of what we have coming up, we do have another session on Thursday, October 22nd at 3 o'clock. It'll be hosted by Helen Fatistas, who's the Executive Director of the Milton District Hospital Foundation. And that session will be entitled An Overlooked Gift, Leveraging Life Insurance to Everyone's Benefit. So I'm sure that's going to be another really informative session. We hope you can join us then. Have a lovely day, and thank you again for joining us. Bye-bye.